Is it possible that during the course of a pretrial deposition of a doctor, I can be professionally friendly with my opponent, with the opposing attorney, and then during the course of the deposition encounter a number of battles where we are arguing viciously with each other, and then at the end of the deposition actually be friendly with each other? You want to know the answer? Come join me for a walk to the train as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer, surprisingly, is yes, that is possible. Now, there are many attorneys that I deal with on a regular basis where we have had many cases together in the past. Now, you should know something else. Lawyers are required to be cordial to each other. Lawyers are required to work together. We are required to be professional with each other. And that rule has actually been written down and recorded by the courts. That's an actual thing that lawyers have to do, because in years past, there were some lawyers who simply were nasty and obnoxious, and they would make things very, very unpleasant, not just for the opposing attorneys, but for the clients and for everybody involved. So the courts cracked down and said, listen, you guys have to work together. You may be opponents, you may be on opposite sides, you may feel in your heart of hearts that each one of you is correct in your assessment of this particular case. And as a result of that, that's perfectly fine to be on opposite sides, and it's perfectly fine to fight on behalf of your clients as hard as you can. However, you still have to work together. So now, during the course of a deposition, I tend to always be polite to my adversary, to the witness I'm questioning. And it's really important for me anyway to do that. So I'm polite, I'm nice, I'm respectful. That's fine. But there are times during a deposition where an opposing lawyer thinks that my question is inappropriate. There are times during my questioning of a witness where the opposing attorney thinks that the topic that I'm talking about is totally inappropriate. And there are some lawyers, some defense lawyers, who think that by yelling and screaming or raising their voice or copying in a nasty attitude or basically being condescending is an appropriate thing to do. There are other times where an opposing attorney will have a legal disagreement with me, and he and I will have a real legal argument about whether or not I can proceed forward on a certain topic or a particular question. And that's perfectly acceptable. But where that disagreement arises and now it escalates, so now each side is yelling at each other, that's not appropriate. However, there are instances where a defense attorney may turn to the doctor and say, listen, doctor, don't answer that question because I want to know an opinion question, and I'm entitled to know that. And I'm entitled to ask a hypothetical question about if certain facts are true, would you agree that it would be a departure from the standard of care to do X, Y, and Z? And the defense attorney may not feel comfortable having his witness answer the question. Regardless of whether he feels comfortable or not, in all likelihood, the doctor's going to have to answer the question. So we may have a heated battle, brief heated battle, about whether or not the witness has to answer the question. And this may go on a number of times throughout the course of the day as I question the witness. There may be instances where it generates bad blood, where it generates a lack of trust, where we clearly don't like each other. But guess what? According to the courts, that should not matter because we have to be professional and we have to be respectful. So now at the end of the deposition, if I need certain things from the witness, I need certain documents, now I have to ask the attorney and I have to be professional about it. This is often surprising to many injured patients and injured victims. And I'll give you a great example. Let's say we're in court and now your case is at trial. And now during a break in the testimony, I run into the defense attorney and we share a brief moment together. And you or someone else sees us from afar and it looks like we're laughing, having a joke together. Well, guess what? That is possible. Doesn't always happen, but it is possible. So getting back to the question that I raised in the title of this video, is it possible that you can be professional and friendly and cordial and respectful with the opposing attorney and then have some nasty legal battles in the middle of the deposition and then still be professional and cordial at the end of the deposition? The answer is yes, that is entirely possible, and that's often what happens. So why do I share this quick information with you? I share it with you as I'm heading to the train this morning going into the city, and I just wanted to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you like listening to the horns honking, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a great day.